Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a lot to talk about today. First, why Justin Timberlake is going to plead guilty. Next, Sarah Boone doesn't want to play lawyer anymore. An ex-police chief is charged a year after a raid on a newspaper. The dad responsible for his son's death gets sentenced, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. Thanks for joining us here on Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps. Now, before we get to the docket, yes, let's pay the bills. Go to CrimeTalkSearch.com. Sign up for that background subscription service today. You may say, Scott, why do I need this? Well, you do. Why? Because if you have somebody important coming into your life, you need to check them out. And as long as you have that background subscription service, when you go to CrimeTalkSearch.com, you'll be able to do as many background searches as you like. You literally get the results as you wait. You can have a copy of it sent to you, and you're going to be able to find out all types of information. Has somebody filed for bankruptcy? Do they have a criminal history? Are they on one of those public registries? Hey, I got an idea. Are they married? Are they being truthful with you? Check it out. It is for peace of mind, ladies and gentlemen. Anyone coming into your life, check them out. CrimeTalkSearch.com. All right. Before we get to the docket, one quick reminder. Our live tonight, 6 p.m. Mountain Time, our Tuesday night live program. We're going to have a lot to talk about. Join us. And one thing we may talk about as well is, Justin Timberlake and why he is going to plead guilty. All right, we're getting more information about the Justin Timberlake DWI arrest. And this is about as generic and Jane plain as you get for a DUI refusal. DUI, DWAI, same thing. DWI, all means the same thing. All right, driving while impaired, driving under the influence, basically as long as the BAC is above 0.080 or higher. All right. So first, apparently Justin Timberlake reeked of alcohol and was unable to follow police instructions correctly when he was pulled over under suspicion of driving in the Hamptons back in June. New police documents provide new details into the traffic stop, which explain why he failed a series of sobriety tests, refused a chemical test, and was ultimately arrested. Like I said, he was pulled over shortly after midnight by a rookie police officer by the name of Michael Arkinson, who allegedly witnessed him blow through the stop sign and swerve in the right lane. That's certainly reason to pull somebody over, no doubt. The police paperwork also shows that Timberlake verbally refused a test 3 times and even refused to the initial document confirming that decision. Now, Arkinson, the police officer, handwritten notes appear to show that the officer followed procedure in the field and determined that Timberlake displayed numerous signs of intoxication, such as swaying on his feet, turning the wrong way, and being unable to keep his balance. Now, Timberlake was alone in the car and was observed to have bloodshot and glassy eyes, odor of an alcoholic beverage emanating from his breath, and an inability to divide attention, and unsteady on his foot. Inability to divide attention simply means you can't do more things than once. Hey, can you get me your driver's license? Can you give me your insurance? Those types of divided attention type of issues. Anyway, the officer stated that the singer said in the report that I had 1 martini and I followed my friend home. Well, that admission in and of itself was enough for probable cause, but wait, there's more. He also noted Timberlake was unable to focus on speaking while looking for his vehicle registration. And the walk and turn test requires the defendant, Mr. Timberlake, to take 9 steps in the straight line, each time placing his heel directly in front of the toe, then to turn and repeat the process. Now, according to the police officer, Timberlake was very unbalanced and was unable to follow those instructions correctly. Timberlake was then asked to raise 1 foot slightly off the ground, keeping it raised for 30 seconds without moving. The police officer also reported that Timberlake swayed while taking this test, needed to use his arms to keep his balance, and put the foot down before the required 30 seconds had passed. And the 4th test in the field was the pre-screened breathalyzer that Timberlake refused to take. That's the little portable breath test. Anyway, so while the results of the breath test are not admissible in court under the portable breath test, they can be used to establish probable cause. I'm of the mindset, and most judges are, and courts are, the law is that if you admit to drinking, that's probable cause to submit to a alcohol test because you expressly consent to give a test if they believe that you are operating a motor vehicle under the influence of alcohol or drugs or a combination of both, ladies and gentlemen. Anyway, the officer then placed Timberlake under arrest, handcuffed him, and then put him in the backseat of the car. Atkinson took inventory of Timberlake's property, which included a Rolex watch, a vape pen, a gold ring, a wallet which contained 3 $100 bills and a $5 bill, and 1 single. He also asked Mr. Timberlake to take a breath test at the police station, the results of which would be admissible in court. But according to the police report, Timberlake refused and said, "No, I'm not going to take a chemical test." Now, by 1:26 a.m., he was read his Miranda rights and told the officer that he understood them and that he did not want to speak without an attorney. Good move. Could have made a couple of other good moves, Mr. Timberlake. The next details of the report come after Mr. Timberlake was rearraigned on the driving while impaired charge in the virtual court appearance last Friday. During the hearing, the judge suspended Timberlake's driving privileges in New York for at least 1 year, could be up to 2. And appearing, Mr. Timberlake pled not guilty to 1 charge of driving while intoxicated. Now, the hearing came after Timberlake's attorney sought to dismiss the case, citing some errors in the paperwork. So the prosecution said, "Fine, we'll fix the paperwork. Get your client here." Like I said, he was allowed to appear via WebEx. That's Mr. Timberlake. And guess what? Timberlake's attorney withdrew his original motion once the paperwork error was dismissed. And the judge also admonished Mr. Timberlake's attorney for his comments, saying that they are irresponsible. Those are the comments that he made to the press after the previous court appearance. So really the bottom line is, will Mr. Timberlake plead guilty to this charge? Eventually he will. Now he's got a court date on August 9th. Do I anticipate anything's going to happen then? No. Why? Because he's still off on tour over there in Europe, and then he comes back to the United States. But he doesn't have to appear in person. But this is a standard routine DWI, DUI, wherever you they call it in your particular state. He was over the limit, .008, and the reason why he's going to plead guilty, at least to a reduced charge, more than likely of driving while ability impaired, is that that's normally what would happen at court. 1, he admitted to drinking. 2, bad driving, failing the roadside sobriety test, which he could have refused. That's why when the police officer says, "Would you like to take some voluntary roadside maneuvers?" Well, if they're voluntary, then I will respectfully decline them. Okay? This is what they refer to, as a double refusal. You refuse to take the test, you refuse to take the breathalyzer, you refuse to give a blood draw. Anyway, given the circumstances here, though, a reasonable jury could conclude that he was driving while his ability was impaired, like a .050 to .799, okay? And that's what will ultimately happen, is my prediction in this particular case. This is a routine, boring DUI, DWI, like I said, whichever they call it in your particular state. These happen all the time. It's a classic, plead it down to a driving while ability impaired and move on. Now, here's the thing that the prosecutors are going to argue at trial. Now, they'll usually get a jury instruction saying that there's a presumption that basically you should take the test, right? Think about it, ladies and gentlemen. If you are walking out of the store, right, you bought some clothes, and they put those little metal tags on them, and you walk through the metal as you're leaving the door, and they beep, 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 beep. What do you do if you've paid for all your items, right? You stop and you say, "Oh my gosh, something here. Here's the receipt. Take a look at it," right? It's the same thing with a breath test or a blood test on a DUI, right? For example, I don't drink. I would love to get pulled over and somebody accuse me of that. I could be like, "You know what? Let's go take that test right now, and it's going to be all zeros, and let's go do this thing," right? And so if there's that one opportunity, that one test, they can say, "I'm not drunk and you're completely wrong, police officer, and everything you've said, everything you've observed or you said that you've observed has been completely wrong, and I'm going to show you." But he didn't. He refused the test. That's why he's going to plead guilty, ladies and gentlemen. Next, Sarah Boone doesn't want to play lawyer anymore. Now, Sarah Boone appeared in court yesterday, and she asked the judge to give her another chance to have a lawyer. Now, as you may recall, Ms. Boone is charged with second-degree murder of her boyfriend, a guy by the name of Jorge Torres, who was found dead inside of a suitcase back in 2020. Now, while Ms. Boone has admitted to zipping her boyfriend into the bag, she denied any ill intent and instead has said that the death was simply an accident. Well, anyway, there was a motions hearing to address several handwritten motions that Ms. Boone had filed since the judge ruled that she had forfeited her right to an attorney. Now, remember, ladies and gentlemen, she's had 8 already, been unable to get along with some of the top defense attorneys in the state for whatever reason. It doesn't matter. It's a her problem. Anyway, the judge had enough, and so she's going pro se. Anyway, the motion requested money for experts and investigators, as well as someone to serve as a standby counsel. And the judge said, hey, you've already got a private investigator, and wait for the name of this company, ladies and gentlemen, Prison Break Investigations. Well, they've been appointed on the case, and they have money. You also have money. She also has money for a mental health expert that has been approved by the court. And what happens is the court will approve money from their budget, and they will provide these services so that they can effectively represent themselves in court. Anyway, Ms. Boone says that she needs more information. She needs an investigator, and that she also, apparently she's having discovery issues, and the judge basically said, we'll get you whatever you need. And then Ms. Boone said something that just brings absolute pleasure to my ears. She says, I don't know what I'm supposed to ask for or who I'm supposed to ask for. And again, I've yet to receive my discovery, so I don't even know what is needed. And the judge said, well, understand that you hadn't received the discovery just yet, but they're going to make sure that you can view all the evidence in this case. And doesn't really matter because you're going pro se, which, like I said, I tell everybody, whether you hire me or somebody else, get yourself an attorney. Don't go to court without one. How do you know what you're doing? How do you know if it's a good offer? Are you familiar with the rules of evidence? Are you familiar with the rules of criminal procedure? Ms. Boone, you're an exhibit A of everyone who wants to represent themselves. Oh, it's so easy, right? It's just a big accident. Just a big accident. You should be able to go to court any day now, Ms. Boone, and tell your side of the story. How tough could it possibly be? How tough could it possibly be? Recently had a case where there was a pro se defendant, and she said, oh my God, this is so much more difficult than I ever thought. And all the rules and the requirements from the judge are just overwhelming. How do you people do this all day long? Well, that's why lawyers get paid. If it were easy, anybody could do it, and they could charge you, minimum wage, I guess. And you're also paying for experience. Experience matters in a courtroom, ladies and gentlemen. Anyway, finally, the judge nixed Ms. Boone's request for standby counsel. That's an attorney that would basically help her understand, answer questions that she may have about trying to get a piece of evidence admitted into evidence. What, you mean it doesn't come in automatically? No. I've seen lawyers that couldn't get evidence in because they thought it was easy, when in actuality, it's quite hard. So anyway, the judge said, I'm not required to appoint standby counsel to you, and you forfeited your right to an attorney. And Ms. Boone says, I do not forfeit my right. That was your judgment. She snapped back at the judge and said that she feels as though she should have some kind of hearing prior to the court's decision so she could have a better chance to explain herself and her understanding. She says that she doesn't want to be pro se any longer. I didn't want to be pro se in the first place, she said. And the judge reiterated that he had read everything in her file and that his order would stand, saying simply, it is denied, period. I love that. I love that when people are trying to game the system and the judges finally call them out on it. And after 8 attorneys, it should have been after 3. 3, you can't get along with 3 attorneys that are more than competent and able. Yeah, go do it yourself. Next, an ex-police chief is charged for a raid on a newspaper. Do you remember this story? It was a little outrageous. So the former police chief who led a raid last year on a small Kansas newspaper will be charged with interfering with the judicial process for actions he took after the raid. Now, this is after a special prosecutor was appointed and prepared a report. Now, the charge against Gideon Cody will be filed apparently this week in the Sedgwick County District Court. Now, the report says that the prosecutors found probable cause that Cody committed the crime of obstruction of justice, which is defined under the Kansas Code as knowingly or intentionally inducing a witness or informant to withhold or unreasonably delay the production of testimony, information, or documents. Now, the prosecutors would not elaborate on the nature of the charge, but said that it was related to Cody's text exchange with the local restaurant owner, Carrie Newell, after the raid took place. Cody resigned from the Marion Police Department within a week after the raid. And the report explains what happened before, during, and after the police executed the search warrant on the Marion County Record, the home of its publisher, Eric Meyer, and the home of the local city councilwoman back in August of 2023. Like I said, now the raid drew a lot of heat from news organizations and freedom of press organizations, as this raid being intrusive and a violation of the First Amendment's concerns. So at the time of the raids, the Marion County Sheriff's Office said it was investigating identity theft and unlawful acts concerning computers based on the belief that the reporter, a guy by the name of Phyllis Zorn, unlawfully obtained Newell's driving records before the paper published a story about her. But less than a week after the national criticism, the prosecutor, a guy by the name of Joel Enzi, withdrew the search warrant and asked the authorities to return the seized matter, saying that there was insufficient evidence to exist to establish the legal sufficiency of the nexus between the alleged crime and the item to be searched. So basically, the judge apparently got it wrong too, because remember, what normally happens is police draft an affidavit. They'll usually have a prosecutor review it, and then it goes to a judge. And then they did this, and they got caught, and then the prosecutor's like, yeah, well, let's just go ahead and give everything back. Anyway, the report's findings in the report, the special prosecutor criticized the inadequate investigation that led to the raid and raised concerns about the motivation behind them, the specter of ulterior motives, personal animus, and conclusions based on not on investigations, but rather on assumptions that permeates much of the case, the report noted. Still, the prosecutors found that outside of Cody's actions, there was insufficient evidence to establish crimes had been committed by any other law enforcement officer or civilian involved in the raids, because they had immunity, because they had the judge sign it. They were just simply executing the warrant, right? They were just following orders. I am so sick and tired of hearing, oh, the line guys are good guys. It's just the top guys. The line guys are just following orders. Well, they also know if there's illegal orders, and if it just smells, they should say, I'm not going to be involved in it, even if it means resigning. Anyway, the evidence prosecutors argue strongly suggests that the law enforcement officers genuinely believe they were investigating actual criminal acts, not just trying to help out the local restaurateur who was going to have a embarrassing article published about them. Oh, yeah. Geez, no, we wouldn't do that in small town stuff, would we? Anyway, the prosecutors also considered whether to charge the officers in connection with the death of the newspaper publisher's mother the day after the raid. Now, Meyer lived in the home of his 98-year-old mother, who co-owned the paper, and he reported she's been very upset about the actions of the police, especially in the service of the warrant in their personal residence. But the coroner found her death was natural, and prosecutors determined there was no evidence to demonstrate the officers intended to cause her death or knew executing the warrant would actually cause her death. Anyway, the newspaper basically says, hey, we believe that justice will ultimately be done, but, hold your breath. Now, there have been some federal lawsuits filed against some of the police officers as well for violations of people's constitutional rights. But once again, it'll be tough because the judge signed the warrants. Next, a bad dad gets sentenced. That's right, the father who repeatedly increased the speed on a treadmill while his son was on it, causing him to fall multiple times, will spend the next 2 decades in prison in connection with the child's death. The Ocean County prosecutor, Bradley Billheimer, announced that a judge sentenced Christopher Greger on August 2nd to 2 to 20 years in prison for aggravated manslaughter and 5 years for endangering the welfare of a child. Now, a jury found Greger guilty of the charge back in May, and Greger must serve at least 85% of his sentence before he's parole eligible. According to prosecutors, on April 2nd, 2021, the Stafford Township Police responded to a report of a deceased 6-year-old. The child was identified as Corey Mikaloa. The medical examiner officer performed an autopsy the following day and determined that the child suffered blunt force trauma injuries. The boy's father, Gregory, reportedly thought that the child to be sent to the hospital, and the victim went into cardiac arrest twice and died shortly after his arrival. Further investigation revealed that Greger had committed acts of abuse against the child while the child was in his care. And after the child's death, investigators obtained surveillance footage showing that on March 20th, 2021, Greger reportedly forced the child to run on a treadmill and kept increasing the speed, causing him to fall multiple times. Now, according to information that came out of trial, Greger was initially charged with endangering the child. And then prosecutors didn't charge Greger originally for the murder until the following year, when an expert witness for the prosecution finally submitted a report concluding the child died from blunt force impact on the chest and abdomen. Now, the child's death was ruled a homicide, and investigators determined that Greger was responsible. The police arrested Greger back in March of 2022. Prosecutors then argued that Greger caused his son's injuries and punishment because his mother brought him home 14 hours late. Bad case. Child abuse, ladies and gentlemen. Yes, parental discipline. Yeah, you can do it. You can do it in most states. You can parental discipline. Yes, you can even spank your child if you think that they need a little attention, so to speak. But you cross that line and it falls into abuse. And finally, our dumb... An Oklahoma woman is accusing an employee at a phone repair store of sending a private video from her device to his. Now, the woman says that she took her phone to have her broken screen repaired and gave it the cell phone as well as the passcode to an employee by the name of Kayan Altoon so that he could do the repairs. He apparently was also the manager. He told the lady that it would take about 30 minutes. So the woman then said that she went to the food court and worked on her laptop while she was waiting. While on her laptop, the woman said that she received a conversation notification, and when she looked at her message, she saw a video had been sent from her phone number to a number that she did not recognize. It was a video of the woman undressed and had been sent to a random phone number, according to the woman. Obviously, she was shocked and surprised. And then the woman said that the text had been deleted when she picked up her phone, but that the message was still visible on her laptop. So she said the video was sent in her hidden folder in the photo app on her phone that had been there at least for 2 years. The folder required a passcode that was the same as that she had given to Mr. Altoon to get into her phone. Well, Mr. Altoon was quite calm and composed when he gave the phone back to her. And the woman then said, he hands me this business card, and it has his name and phone number on it, and it says to call him or text him if you got any more problems. The woman said after looking at the business card, she immediately recognized the uncommon area code that was on the business card, and later confirmed that that was where the video was sent. Anyway, when the police were investigating, an officer made contact with Mr. Altoon and called the phone number that the message had been sent to. When the officer called the number in front of Mr. Altoon, guess whose phone rang? That's right, Mr. Altoon. Needless to say, Mr. Altoon was arrested for theft and computer crimes and has posted bond. No word on when his next court date will be. Ladies and gentlemen, the phone, man, it doesn't forget. And if you're going to be creeping in somebody's phone that you're supposedly working on, and you're going to send images, have at least enough sense to send it to a burner phone, for God's sakes, Mr. Altoon. That's why you are our dumb criminal of the day. Or better yet, Mr. Altoon, just do your job and don't go around creeping in other people's private stuff on their phones, right? They have an expectation of privacy there. All right. That's all we have for today, ladies and gentlemen. Join us tonight, 6 p.m. Mountain Time for Tuesday Night Live. And remember, the Constitution matters.